good morning, so nice to see you, and of course, thanks for being here at 8045. I mean, we understand that it's still the first day, but it's also nice to see that you have found your way, to this new building, this year at CPDP, so thank you so much for being there. I will be quite short. I will be the moderator for this session. For those of you that do not know me, I'm Giovanni De Gregorio, and I'm an associate professor at Cattolica Global School of Law in Lisbon. And here, I have, of course, as I told you, the pleasure of introducing to this actually very interesting panel, that comes from actually different places and expertise. But I'm going to introduce each speaker while they're going to speak. Just I wanted to tell you some what we're going to talk about today and some house rules while some people are joining, so we can still be and give you a little bit of introduction. So first of all, the title is quite self-explanatory if you want, and it's also a big title in terms, it creates a lot of expectation on this panel in terms of talking about fundamental rights and artificial intelligence for so many reasons, and for all the attention that has been put on the AI Act on fundamental rights, but also from so many other issues related to artificial intelligence and the protection of rights and freedoms in the digital age. So, of course, we are going to hear different speakers presenting on different issues, as we are going to see, and I'm going to introduce all of them. Please. And, okay. So there are also some spaces there, some here, at the front. No, it's not the best sometimes, but still. Okay, so, some house rules. We'll have the speakers presenting like 10, 12 minutes, and then we'll open to the floor, okay? So we'll try to moderate and opening to the floor. Having said that, let me say that we have the pleasure, of course, to host, Michel Fink, that will be the first speaker. Then we'll have Simona Denkova, Andrea Scerban, and Marco Bassini. The project actually, and the panel is supported by the Encrypt project, and Marco will have the chance to tell you a little bit more about the project during the panel, okay? This is just a little bit of house rules. So I would say, without further ado, while waiting for everyone takes the seat, that's nice, please. Take your seat. Fantastic. Maybe I should do another round, but I would not do that. Anyway, so I would say, without further ado, thanks again for coming, and we are going to open this first panel on fundamental rights and AI with Professor Michel Fink. There is a professor of law and artificial intelligence at the University of Tübingen in Germany, and she was going to speak about the fundamental rights and AI, particularly with a focus on fundamental right impact assessment, if I'm not wrong, and all the questions raised broadly speaking, and to frame what actually the most important challenge is when it comes to the protection of rights and artificial intelligence. So I will leave the floor just to start this, because we want also to have time for conversation, to Michel. Michel, please, the floor is yours, and then we move to the other speaker. And thank you so much to be here again.
So thank you so much, Giovanni. So what I'll try and do is just kick off our discussion this morning by talking about the fundamental rights aspects of the Artificial Intelligence Act. Now, you couldn't possibly say all of the things that fall within this broad topic within the 12 minutes that I have, but I'll essentially try to sort of give an overview of what the role of fundamental rights in the Artificial Intelligence Act is, and also talk a bit about the legislative history behind that, which I think is quite key to understanding the final text that we now finally have. Right. So these are the three parts of my presentation. I'll start by talking about the legislative history of the Artificial Intelligence Act, with a focus on discussions around the role of fundamental rights within this legislative framework. I'll then go over some key provisions in the final text from a fundamental rights perspective, and then finally I'll close my presentation by introducing the fundamental rights impact assessment, which is of course a key mechanism in this regard. Right. So why do I start with legislative history? I mean, first of all, this is, I guess, where we generally start when we talk about this new legislative instrument, right? Because it was just finalized. But I think it's a perspective that's particularly important when talking about the role of fundamental rights, because the role of fundamental rights in the AI Act was one of the most debated and controversial aspect of this regulation as it was being negotiated over the last couple of years, right? And so the point to start with is maybe a reminder of what the Artificial Intelligence Act is, right? So we're really talking about, I think, by and large, a replication of EU product law. So this, by and large, resembles very strongly EU law instruments that have existed for decades under the new legislative framework. And this essentially means that this is secondary legislation that outlines broad principles that are then translated into harmonized standards, which in turn give rise to a presumption of conformity for those that adhere to them, right? This is an instrument or way of regulating things that's very familiar in EU law. So, for instance, this is how the EU has regulated things such as toys or washing machines and dishwashers. And of course, you'll see that these are products that generally do not raise fundamental rights concerns, right? Now, in relation to AI, the situation is, of course, very different. And this was acknowledged all along the legislative process, right? So if you, for instance, look at the support study to the impact assessment from 2021, then it's very clear that there was a recognition that AI is a technology that raises fundamental rights concerns, right? So the support study concluded that there is strong evidence that certain uses of AI systems can significantly impact all fundamental rights recognized in the Charter, right? So we really have this interesting situation that the AI Act is by and large a replication of EU product legislation, but it regulates products, AI systems, that unlike other products that are regulated by EU law, can raise fundamental rights concerns, you know, unlike what is the case in relation to a dishwasher, for instance. Now, notwithstanding this situation, the use of the new legislative framework to create the AI Act was a deliberate choice, right? So I think there was always this awareness, okay, we're using a mechanism in EU law that we've used in the past to regulate products that do not raise fundamental rights concerns, to now regulate artificial intelligence, which of course does raise these concerns, right? And I think there's many reasons as to why this deliberate choice was taken, and I think one that's particularly important to bear in mind here is simply the division of competence between the EU and the member states, which made this one of the choices that was available to the European Commission when it crafted the draft AI Act. Now, because of this situation, right, you have a legislative instrument based on product law regulating AI, which does raise fundamental rights concerns. You had this really interesting discourse from mainly the European Commission from the time that the draft AI Act was published. So on the one hand, you had this instrument really based on product law, but most of the discourse that was focused or that was sort of used by the European Commission to describe this new legislative instrument focused really heavily on fundamental rights, right? So if you had just read sort of like the different press releases and news conferences that were given by the European Commission, there was such a strong focus on fundamental rights that you would have thought that actually there's a really strong there are really strong rights protecting instruments in this text, unlike what was actually the case when you looked at the draft AI Act. This, of course, also led to a critique. So a number of commentators criticized that there was insufficient protection of fundamental rights under the AI Act. So, for instance, in a paper that was published by Nathalie Smuha and her co-authors, there was a critique that there were sort of no new mechanisms to protect fundamental rights in the draft AI Act, and other scholars also criticized that fundamental rights were but an afterthought in the draft AI Act, which after all was mainly focused on replicated on the new legislative framework. In the course of the legislative procedure, this then led to the European Parliament advocating for the incorporation of provisions that were specifically related to fundamental rights, such as the fundamental rights impact assessment, which, as we'll see, has been incorporated in the final text. And there were also other NGOs, but also academics that released, for instance, open letters to advocate for the inclusion of this instrument. Right. So what does the final text look like? We still have this strong focus on product safety regulation. So you could say that the final text is very much a cake of product safety law with a few sprinkles of fundamental rights on them, right? And these sprinkles of fundamental rights in the final text, they don't really resolve this conceptual tension that we have that stems from the fact that product law, like legal instrument, is being used to regulate something that does raise fundamental rights concerns. And I'll briefly go over a few results of this conceptual mismatch. So I'll talk a little bit about the fact that there's a discussion as to what the risk to fundamental rights even is, as it is being phrased in the AI Act. Then I'll talk a little bit about the standards as a mechanism to protect fundamental rights under the AI Act. And finally, I'll say a few words about the fundamental rights impact assessment. So if you look at Article 1, Paragraph 1 of the AI Act, you see that this outlines the purpose of the Artificial Intelligence Act, right? So it tells us that one of the roles of this regulation is to ensure a high level of protection of health, safety, and fundamental rights as enshrined in the Charter, right? And then in the text of the AI Act, you oftentimes find this notion of risks to fundamental rights. And this has led to a debate as to what a risk to a fundamental right actually is, right? So the AI Act itself, it defines the notion of risk. In Article 3, Paragraph 2, this definition is set out. So this article tells us that a risk means the combination of the probability of an occurrence of a harm and the severity of that harm. However, some scholars, such as Mireille Hildebrand, have underlined that in EU fundamental rights law, there's no need to prove that there is harm or likelihood of harm, right? So in EU fundamental rights law, rights are considered to be safeguarded as inherent rights, implying that any infringement upon these rights constitutes a violation in and of itself, thus without needing to think about whether there was or could have been harm, irrespective of harm materializes, right? So I think going forward, we'll see a debate as to how to even make sense of this. We can look at the existing body of product law to think about what a risk to health and safety is, but this notion of a risk to fundamental rights, I think, is one that is yet to be defined. Another implication of the odd status of fundamental rights within the broader AI Act is that standards will have a role to play in how fundamental rights-related provisions of the AI Act will come to be interpreted, right? So standards are a key instrument under the high-risk AI systems regime of the AI Act, which will essentially flesh out the broad guidelines of the regulation in relation to high-risk AI systems. And that means that standards will also define fundamental rights-related aspects, such as, for instance, that which we find in Article 10.2f, which requires an examination in view of possible biases that are likely to affect the health and safety of persons, have a negative impact on fundamental rights, or lead to discrimination prohibited in EU law. Right? There has been a lot of critique around the standardization process because of the fact that standards are typically drafted by technical experts, because of sort of political dynamics involved, and all of these critiques are, of course, even more powerful when it comes to fundamental rights. So I think likely what we'll see is that standard setters, which have themselves publicly said that they're not particularly keen on having to deal with fundamental rights, they'll come up with very broad processes which then in turn are likely to sort of create a presumption of conformity, and then there will be questions as to what this actually means for the substantive protection of fundamental rights. And then finally, I want to say a few things about the fundamental rights impact assessment. So this is a mechanism that we find in the final text. It was not part of the draft AI Act. It made its way into the trilogues due to the EP proposal, but also due to a letter initiated by Alessandro Mantelero and Giancarlo Malgieri, which received a prize for this yesterday. So we now find this instrument in Article 27 of the AI Act, which requires a fundamental rights impact assessment for Annex 3 high-risk AI system. Deployers that are bodies governed by public law are private entities providing public services, as well as for deployers of systems designed to assess creditworthiness and credit score, as well as in the context of life and health insurance, right? So Article 27 tells us the elements you have to take into account when carrying out a fundamental rights assessment. So things such as the description of the deployer's processes, description of the period of time, and so on and so forth. But as you can see, these are pretty general guidelines, right? So we really have to wait for the AI office to provide a questionnaire. The fifth paragraph of Article 27 tells us that the AI office is mandated to create such a questionnaire to see what this really requires in practice, right? Some people have speculated that this could be a pretty sort of vague questionnaire, so that you wouldn't be in a situation where the fundamental rights impact assessment would be pretty much of a box-ticking exercise. But of course, this could also look different. But I think essentially we'll have to wait for the AI office to act on this to know more about what fundamental rights impact assessments under the AI Act really are. So I'll stop here, and I'm very much looking forward to the discussion. Thank you.
Thanks a lot, Michelle, of course, and I mean, it's interesting to see now how the discussion is not really just about, understanding, the risk and the connections between fundamental rights and AI, but we're also trying to operationalize, to understand what does it mean when it comes to regulation, protecting fundamental rights, and all the discussion about risk-based approach, enforcement, the fundamental rights impact assessment we have addressing together are ways that still need to be quite unpacked, but are ways to move forward in the discussion, Maybe are not the perfect ones, but still it's at least the European way to do that. Without further ado, because that is not my role, but I mean, I can introduce to you Simona Denkova, that now, and she's going to talk about another important part of this discussion on AI and fundamental rights. It's about exactly the procedural safeguards. Simona is an assistant professor in European law at Leiden University, and she's precisely going to talk about the questions about procedural safeguards when it comes to the protection of fundamental rights and when we deal with AI. It's another super important point. So it's also important. It's important to focus on substance, and now we're also looking a little bit at procedure, because this proceduralization has become an important part of the European strategy to address the protection of rights in the digital age. So Simona, the floor is yours. Thank you so much. Of course. Wait, because this light. Okay. Should work.
Thank you, and very good morning also from my side. It's a pleasure to be here, and as Giovanni said, I will talk about the procedural side of things, especially when it comes to AI Act, but also how it relates more broadly to EU law and the general principles that we already have under EU law. Also because perhaps there is less that we can do to protect the substance of certain decisions that are determined by the uses of artificial intelligence tools. So wait a second. This is it. Yes. This work is part of a project that I'm leading at Leiden University. It's funded by the Leiden Starting Grant. The project is broadly focused on the EU human-centered digitalization, but what that term means, we are trying to, together with a colleague of mine, Daniel Mandrescu, we are trying to uncover maybe ways to induce compliance culture in the EU when it comes to the uses of AI, with a certain EU legal mindset when it comes to also fundamental rights protection. So just to spend a little bit of time on the term of human-centered that I have particular issues with, because it originates more or less in an idea that has nothing to do with rights protection. It's a computer science notion whereby we're trying to ensure effective control over the uses of artificial intelligence tools. But under the EU digital policy and technology policy, we are infusing that notion with rights and values that exist under EU law. So we're giving the human-centered approach, if you like it, the regulatory approach, constitutional aspirations. And it is our role as researchers, as lawyers, as practitioners to contribute to ensuring that that kind of approach is also feasible in practice. And so what I wanted to focus on today is looking specifically at the procedural safeguards that exist under the AI Act with respect to both the individual decision-making, specifically where AI tools are used, and some observations also on the procedural setup for remedies that, of course, we can talk about rights protection without having effective access to remedies. So very briefly again, what's the EU's vision for human-centered AI like? We can look into the AI Act preamble, and I will be very brief on this. In point 6, it is stated that it is vital for AI and its regulatory framework to be developed in accordance with Union values as enshrined in Article 2 of the Treaty on the European Union, fundamental rights and freedoms, and that as a prerequisite means that the AI technology should be human-centric. It should serve as a tool for people with the ultimate aim of increasing human well-being. A rather large, of course, aspiration for the future. One of the ways to ensure the human-centric AI is implemented in practice is the guidance offered by the high-level expert group on artificial intelligence and the ethics guidelines for trustworthy AI, which together include 7 non-binding ethical principles that you are very well aware of, hopefully, or if not, I will not spend too much time on this, but these non-binding principles are now in a way, more or less, translated into legally binding obligations within specific provisions in the AI Act when it comes to transparency, when it comes to human oversight, when it comes to data management, also data protection, etc., etc. And just the last point on how to ensure this vision, of course, the purpose of the AI Act, as stated in Article 1, is to first and foremost improve the functioning of the internal market and to promote the uptake of AI within the internal market, and at the same time ensure a high level of protection of health, safety, and fundamental rights at the same time. This means, of course, we are dealing with an internal market regulation. We very well know that it has a product safety nature, but it is also exceptional in the fact that it includes very specific rights and provisions concerning implementation of fundamental rights, which is rather unprecedented when it comes to product safety rules in the European Union. So this brought me to a question that I want to explore, how to apply the procedural safeguards that arise under AI Act to ensure a human-centered fundamental rights protection. A rather large challenge, so today I will just give you a little of my first thoughts on the topic, and hopefully once I write it up in a paper, you can read about it more. This is a topic that we have started exploring with some colleagues, also from Leiden University, looking at the role of general principles of EU law in maybe filling up the gaps that arise in the secondary rules that appear under the secondary legislation that is the AI Act, because we need to always think of these rules as applicable in conjunction with already existing primary EU law. One such effort was the symposium we organized for the Digicon blog last year on safeguarding the right to good administration in the age of AI. There will be another panel in the ICON-S conference where we will discuss this, bridging public law, European public law views on the topic that perhaps is more or less private regulation of technology. And so, drawing on insights from regulatory theory and together with European legal scholarship, I will focus on the two types of safeguards in individual decision making and the remedial procedures. I would also like to set this theme within a broader theme of constitutionalization in the European digital policy that is taking place, within which the focus on procedure is becoming ever more evident. As I already said, we're using the legal basis of Article 114 of the Treaty on the Functioning of the European Union, which is not unprecedented. Of course, again, regulating internal market. This is the legal basis that has been used to expand also the influence, if you like, of the European Union intervention in many spheres, beyond, of course, the regulation of technology. The scholars have been already looking at what this means for the development of European integration more broadly. For instance, Giovanni Comandè, already in 2014, has named EU citizenship as the fifth fundamental freedom. So we're moving in an internal market beyond just the protection of the four fundamental freedoms, or freedom of movement, of services, of people, of goods, to really constitutionalizing also the market objectives. And more recently, the scholars, like a collection of studies in a recently edited volume on the European integration and harmonization of rules, have also identified that now we're also entering Article 2 values of the rule of law, protection of democracy, of human rights, and the protection of the charter rights within the objectives of the internal market rules. And this is important to realize also when we look at what is happening in the digital regulation as well. And there are many reasons why we would then also see the larger importance put on procedural protection rather than on substantive protection, because we also have less, perhaps, expertise in certain scientific areas of law, like the technology case, where we need to delegate certain powers to more specialized institutions, more specialized agencies, to prepare the technical rules to be applied so as to protect also fundamental rights. And this is what Marco Almada also discusses in his upcoming PhD thesis, looking at the importance of the technology neutrality as a way to delegating the content of the rules to specific technical bodies. So standardization as an example, whereby we give up some sort of control over the substance of fundamental rights protection, and where procedure becomes important, because we can only control, or not only, but largely control what happens to the substance through effective protection of the procedure of delegation, but also of the rulemaking procedure that takes place. So I would say that one way, or one emerging way of ensuring fundamental rights protection in the age of AI is indeed through procedural safeguards. And this is whether we like it or not. This is not to say I give up on protection of the substance, or we have no way of controlling for the fairness of decisions, which of course concern substantive issues, but also looking at the construction of the AI Act as a legislation, we can see that a lot of the safeguards and rules put into the specific provisions of the AI Act largely focus on ensuring effective procedural steps within a certain decision-making procedure, so as to demonstrate compliance rather than demonstrate substantive correctness of an outcome. And this is not only a development that takes place in the AI Act. Of course, the Court of Justice has been developing its jurisprudence through this interaction of a deeper procedural review in questions which concern fundamental rights. For instance, my colleague Giulia Gentile identifies this looking at the double dynamic between the application of primary law guarantees, so the general principles of EU law and the charter rights, in conjunction with GDPR rules, or now with the DSA rules on remedies, or on due process rights. And we can identify the trend that the court, indeed the Court of Justice, has been in the active role and its activist role in developing very deep or higher intensity procedural review in these questions where technology poses significant risks to fundamental rights. And only then we saw the legislators stepping in. Oreste Pollicino recognized this as another wave of intervention coming from the legislators now only after the first judicial activism phase. And also the way in which this has been done has been named regulatory brutality by Papakonstantinos and De Hert, very tellingly that we have embarked on a large-scale legislation, adoption of a lot of legislative instruments that do not talk to each other. So this step out of the sectoral rules and maybe looking at what the EU law already in its primary law form has to offer and how it can coordinate the interpretation of these rules is an essential way forward. So without talking too long, I would just make a few key observations on the procedural safeguards that I find with respect to AI-driven individual decision-making. First, as I already said, all the AI Act obligations are secondary to other existing EU law. This includes both the primary EU law, but also secondary rules like the GDPR, which come as lex specialis in relation to AI uses, which of course process personal data. And another observation I could make is that procedural safeguards apply based on the extent to which the system, the AI tool, impact decision making. This is obvious from the definition of the high-risk AI in Article 6, which in paragraph 3 actually makes an exception, for instance, to the determination of high-risk systems in the Annex 3, which says that only to the extent that it doesn't impact the final outcome of a decision, it would be considered a high-risk system. And then there are instances in which perhaps if it is only to improve a certain content of a decision, then it wouldn't be considered high risk. But of course, we know that the line is very thin in deciding when our reliance on a specific tool is also determinative for our decision. And the only guidance that we have on this so far when it comes to jurisprudence is the Schufa holding case of the Court of Justice, where there was, however, a rather clear connection to the Article 22, because it's also one of the forms, credit scoring is one of the forms that is recognized as a form of profiling in the GDPR. So I don't think it provides us enough innovative interpretation, if you like, to be applied in other systems where maybe the link between the use of AI system may be lesser, but still substantively affecting the decision in the end. Another point, protection of fundamental rights is not absolute, as we know. It's always subject to certain limits, to proportionality assessment, and AI Act itself comes with a lot of exceptions to the rules and also to the application of the safeguards. Most of these exceptions, however, apply to, in my opinion, rather high risk, very high risk uses of AI systems, like in the context of law enforcement, migration, asylum procedures, where we know that people are particularly vulnerable. So the application of these exceptions needs to be subject to the assessment of proportionality under the Charter, Article 52 assessment, rather than just balancing between the if you like, between the necessity interests when it comes to the use of AI under the secondary rules. And last observation I would like to make when it comes to the proceduralization trend under the AI Act is that those rules are going a step further in harmonizing national procedural rules, because we at the European Union level, we have certain competences that are conferred on the European legislators to regulate certain areas. But when we consider procedural safeguards applied, for instance, to the law enforcement context, like the obligation to have a judicial authorization for the real-time biometric identification systems in publicly available spaces, this is as a clear procedural obligation that wouldn't exist under other rules of EU maybe directives on criminal law that would harmonize criminal laws of the member states. So also through this secondary technology regulation, there may be a side effect in EU law towards greater harmonization of member states' rules, also in areas where perhaps no rule exists on the member state level, because it's an area which hardly any member state has AI legislation already in place. How much time do I have? Can I have 2 more minutes? Okay. Then I would want to say a couple of words about what would make a good decision-making procedure and compare then the rules that we have in the AI Act in addition to what I already said about the definition of a high-risk system in Article 6. Most of the obligations under the AI Act do actually point to enhancing the ability to control, so the procedural ability to demonstrate control over decision-making through, for instance, the transparency obligations. You need to provide information on the operation of a specific system, including the use instructions, including, substantively what these instructions, how to use the system, so what the information should be included, but still with the view of allowing then human oversight so as to protect against the tendency to over-rely on automated outputs, if you like, and also provide for steps so as to ensure that a person that does have access to an output from an AI tool has an ability and competence to decide not to rely on the certain output. A specific obligation procedurally, for instance, that is interesting. Sorry, I didn't put it up. The specific tendency that is interesting to note is that you should be able to rely on an AI-given output only after it has been separately verified by at least two human beings, two human agents, two decision makers, which of course in practice makes it difficult, with exceptions, of course, for law enforcement sector where timely decisions are necessary. And for instance, there is an obligation to inform about being subject to an AI use, which also it's a procedural obligation rather than a substantive one that allows us to control the decision as such. In EU law, instead, we have provisions coming from the right to good administration under Article 41, together with the right to an effective judicial protection under Article 47, which of course apply only to the public authorities, and we know the obligations under the AI Act concern also the developers of the AI system as well as the deployers of the AI system that can be public authorities, but some convergence of the obligations under the notion of the duty of care that the Court of Justice has developed out of the right to good administration as an individual right in the European Union has the potential to extend the protection of fundamental rights also to horizontal relationships between an individual and private actors. And what a duty of care as a review criterion can offer in this case, or it could bridge the requirements under the secondary rules with the primary EU law requirements by focusing on gathering on having two types of obligations. Factual obligations requiring that the decisions that they rely on complete, relevant, and factually correct information, with the ability of the decision maker to actually weigh the correct interests and rights that will be affected of the individual. So this is where the human decision maker comes into place by being able to balance and reason about the impact that a certain tool may have on fundamental rights, as well as qualitative obligations, including the requirements on the information reliability when it comes to both the source of the data, which is relied on for certain decision making, but also on the procedure that led to the adoption of that decision making. Of course, the application of the duty of care requirements is also context dependent. It depends on whether we're talking about general decision making when in the context of rulemaking, where we give larger discretion to the authorities to decide on the substance, for instance, of the reasons to be given or the extent of the reasons to be given for certain decisions. But in single case decision-making, on individual decision-making, the court usually applies relies on the duty of care to go for a rather stricter intensity of review to control for also substantive quality of the decision, if that makes sense. And just one last point on how to actually then achieve fundamental rights protection through procedures under the AI Act. Then we know that under AI Act, and now Section 4, we included the section on remedies. This is also information that from an article that I co-authored together with Giovanni, that you can find on the QR code. And I just wanted to say here that the right to explanation, and what we call the internal complaint mechanism, will become key actually to bridging these essential procedural obligations under EU law with the procedural safeguards under AI Act, because this allows us to complain or demand the same standard of duty of care from both private and public authorities or actors using and deploying AI as we would in the context of only public authorities. There are, of course, question marks when it comes to remedies before independent supervisory authorities. All eyes are on the data protection authorities, but little is known yet about the coordination of the competencies on the national levels, also because the right to complain to a market surveillance authority that has been included in the AI Act doesn't really extend as far as provide a remedy before an independent data protection authority. And then we have, of course, judicial remedies, even though none are provided for in the AI Act. Recital 170, of course, states that remedies as already existing under EU and national law continue to apply, so the individuals should rely on those. These exist under Articles 19 and 47 of the Charter. The member states are responsible for actually effective enforcement of EU law, including effective protection and delivery of effective remedies to individuals in all spheres where EU law, of course, applies, which AI Act, being a regulation, applies almost everywhere now. So I will leave these concluding remarks here, stating that some questions or open questions when it comes to how to ensure the deep procedural review in this context include how to ensure coherent interpretation across different member states, because we will still have different rules on procedures applicable, but also different authorities intervening. So knowing that we can look for inspiration in the national legal orders, and then this is the common problem in cross-border interpretation of rules. Maybe looking into the questions of further harmonization of procedural rules. There have been attempts at the EU level, non-successfully, because it's such a sensitive issue also for the member states to give up their national procedural autonomy. The AI Act actually has the potential to go further and harmonize certain rules, perhaps as a side effect. And some points on actually the access to remedies. I already said those, so I will not repeat. Thank you for your attention, and I will leave the floor to you.
Yep, thanks, Mona. So thank you so much. I think this, please, no worries. This part of, I mean, as you can see, I mean, basically it could be like other 2, 3, 4 presentations. There were so many things actually in this presentation that could be further developed, but we'll leave also for later, and I will immediately move the floor to Andrea Shirban, that is there actually, in like on the other side of the table. He's a privacy and analyst for global policy at the Future of Privacy Forum, and she's going to speak starting from some lesson learned from the GDPR. It's another super important topic when we move to AI. So continuing this connection, so Andrea, please, the floor is yours.
I will join there.
Please.
I think it's going to be a better conversation like this. Good morning, everyone. Thank you so much, first of all, for inviting me to this panel. It's very interesting to bring all of these perspectives together, as I feel like we are now in a conundrum where we have to bring a lot of voices. We have to make sure that we have a multifaceted approach to everything that we are discussing when it comes to the AI, given the fact that the AI itself is being developed as we speak and is getting developed all the time. Therefore, it's important to keep up with all of these and to try to find a middle way. Now, my presentation, my intervention today is not based on a presentation on PowerPoint. I just wanted to maybe summarize a couple of important things that we have learned from the lessons of the GDPR and give you some food for thought, maybe pose some questions, something that we could answer together. Maybe we can start a conversation about it. But it's just something that could maybe be of interest. I'm really happy that the occasion now has come to bring a bit the conversation in relation to privacy, as privacy is a very important aspect of the AI in general here. Now, we know that technology is evolving faster than ever and faster than law can keep up with, and we know that because we already have now a new AI Act that is still being debated whether or not it's sufficient or not, should it be improved, what is going to happen next, and so on. But we have it now. We already have an approval from the Council. So as we embark on this journey, we have to look at this comprehensive legal framework that is dealing with all of these challenges. And we need to take into consideration all these efforts to align all these definitions coming from regional, from international level, and to try to find a middle way. Now, why the AI Act matters? First of all, it's because we have no other current framework at the European Union. So we need to build from somewhere. And the AI Act is going to be quite a very interesting starting point. Of course, the hard work is only now beginning because we have to bring all of these bricks that is going to create the legal framework as we want to imagine it. But we already have had some other discussions a couple of years ago that have been going for 5 years. And it feels a bit like the Groundhog Day, I would say. At least this is the feeling that I'm getting, because we do find ourselves in a very similar position to where we were only a few years ago when we adopted the GDPR. What we have to do at this critical point is to recall some of the lessons that we learned from the enforcement of the GDPR and maybe step back, take a look at the ecosystem that we have of the new data protection laws and data related legislation, but from a fundamental rights perspective. What we know is that there is a very clear goal, interplay between the goals of the GDPR, which has been focused a lot on fundamental rights protection, and the developments of the AI systems. Now, from our experience with the GDPR and the protection of personal data and the protection of the individual and privacy, we believe that there are a couple of important synergies to tap into and to leverage them into implementing the AI Act and to make sure that we build a successful AI implementation overall. So with this, I would like to make a couple of points that can be further developed, of course. But I would like to bring our attention, first of all, to the data protection impact assessment, because the GDPR has actually solidified this impact assessment as a tool for regulating technology. And here there is a very interesting interplay between the GDPR and the AI Act, because we have the potential overlap between the DPIAs with the fundamental rights impact assessments. There is a fundamental rights impact assessment provision in the AI Act making specific reference to pre-existing DPIAs that need to be taken into account. The fact is that most organizations, both in the public and the private sectors, have ample experience with the DPIAs to identify and mitigate the potential risks to fundamental rights arising from the processing of personal data. And now this experience and know-how can be leveraged into the context of the AI and of the artificial intelligence. Another point that I would like to make is that we have a very vast experience, which is now becoming a very good asset into the pool of the DPOs and the privacy officers. Not only, of course, because of the substantive legal reasons and the efficiency of resources and effective implementation resources. The GDPR, what has done was to create this infrastructure of human resources in the past 5 years within the companies, in different entities, public, private sectors. They already have the knowledge on how personal data is being collected, what are the purposes, how it is being used, how it is being shared, how it impacts the rights of individuals and even the communities. So this infrastructure and this experience can and should be brought into the discussion when we discuss about implementing the AI Act. Another point that I would like to make also is upholding the principle of data protection by default and by design and by default. Of course, this principle has been maybe a bit underexplored within the GDPR, but it's still something that could be the key in ensuring the development and deployment of the AI systems lawfully while respecting fundamental rights. We are talking about starting from the early stage of preparing the data sets for training and following the AI Act, the AI systems through their life cycle. So this is also another point that we can take and further discuss. And finally, when we are discussing about the privacy enhanced technologies, well, the pets are coming as a renewed interest by the regulatory authorities in the AI development, particularly from a privacy and data protection perspective. And this can be seen not only in Europe, but also globally, as we have, for example, the emergency of regulatory sandboxes, and we have examples from other countries, such as Singapore and UK. Well, all in all, as I don't want to go further, as we would like to have some time for conversations, I would say, it feels like this is a never-ending story, because in fact, with every single product, everyone wants to be first, everyone wants to come on the market first, and everyone wants to make sure that they are already out there sometime in this process. There are a couple of things that are being overseen, so we need to make sure that enforcement here is key, and we need to make sure that we have some clear boundaries where we are not having products that infringe fundamental rights. Therefore, we need to make sure that enforcement is key, and this is going to be a very interesting point for the future, as also was mentioned earlier in the previous presentation, as there's still something to be discussed in practice as how the enforcement is going to look like when implementing the AI Act. But there are a couple of things that I would still like to make sure that everyone takes away from this presentation. There are 3 words: fairness, accountability, and transparency. And I would say that these words should guide us when discussing the implementation of the AI Act. And we have to look, in the end, at the GDPR as an inspiration, as a source of inspiration to move forward, because there are so many similarities in the policy-making side, also in the implementation side, and also how we are relating to the entire process. So it's going to be very interesting to see what are going to be the developments, and I'm really happy to be here to discuss how it's going to happen soon. Thank you so much.
Thanks, Andrea. Indeed, I mean, it's quite interesting to understand. I mean, of course, it's quite, clear the interrelation between the GDPR and the AI Act. The problem is that how they will look together, especially when it comes to combining also the risk-based assessment, including both legislation that are quite different, even if we're still speaking about the risk-based approach. So thanks, Andrea, for that. Without further ado, I would move to Marco Bassini that is there. And let me introduce Marco. He's an assistant professor in artificial intelligence and fundamental rights, actually, at Tilburg University. So he will deal a little bit about the Encrypt project. Who actually supporting this panel, and just going towards another kind of issues related to security and encryption that are also relevant for what we are talking about today, and also the discussion in the European policymaking at the moment. So Marco, please, the floor is yours.
Thanks, Giovanni. I will speak from the table so we speed up the process. Thank you everyone for joining this panel. And as I said, I will spend a few words to follow up on our conversation on the Encrypt project, and then I will say a few words about what I feel to be a very key point that also the project can show in a way, so the role of technology as a tool for regulation sometimes. We are used to think about technology as a target of regulation, but sometimes we can also see some possible potential in the use of technology for governing what's happening in the digital sphere. What about Encrypt, first of all? It's a Horizon-funded European project gathering different expertise, technical expertise, and of course also legal ones. And it comprises 14 partners from 8 European countries. And the goal of this project is basically to build a scalable and practical framework for the use of privacy-preserving technologies. And this is a key point, I think, in the conversation we can have about the potential of technology in supporting compliance, and particularly when it comes to fundamental rights, as the assumption and the observation of the state of the art from which the project moves is that privacy-preserving technologies have a huge potential, but they are still in a way underdeveloped because, of course, they are very promising at a small scale, but in order to be applied to real-world use cases, they need to be further implemented and combined and put together. And that is why the project actually wants to build this framework and to be actually a technical solution in order to make sure that different technologies can be combined and made available in order to make sure that privacy-preserving technology solutions are applicable to, as I said, real-world use cases. Why? Because we know that more and more, and this is definitely also connected to AI, we need to process data, let's say, on a federated basis. We have many actors involved. We have multi-stage processing. We have multi-actors processing of data and in the real world. And this makes, of course, material the existence of threats for fundamental rights to privacy in a way. Data, in a way, are supposed to circulate, so we actually see perhaps a risk that is inherent in the fact that data are processed by many actors. The idea behind the project is to make sure that technology can support actually privacy and can foster privacy while facilitating the use of data by a variety of actors. So, this is the most important challenge we are facing in the EU in particular now, to make sure that we have a data-driven economy, but at the same time that we preserve privacy. And this is actually the rationale behind this project. The project had basically 3 use cases in mind. What I mean by that, I need that in order to develop a solution for making sure that privacy-preserving technology can be properly implemented, of course, we need real cases to see what may happen if we use this combination and this framework. In order to build this framework, different contexts can be taken as an example. For example, the financial context, and where we have maybe financial institutions or banking institutions that need to know data and we need to get information about individuals. The medical context, where maybe more medical practitioners may have the need to consult data, to access data from different institutions, from different centers, and also the context of the prevention of cyber attacks and cyber threats, where we can collect and expect that there is a collection of data making possible to determine when cyber attacks are likely to occur, and then to implement all the necessary arrangements to make sure that these threat can be detected. These are, for example, the use cases where the project is focused in order, of course, to understand whether this solution can be developed. And, of course, this is very important in respect of the possible solution that the project aims to develop, because we see that there are now constraints on the use of privacy-preserving technologies, and we need to make sure that these constraints are actually overcome. So the challenge behind the project is to overcome this challenge and make sure that this can be further developed and implemented in real-world cases. Of course, one of the constraints is GDPR compliance, because only in certain circumstances we can rely on fake data or synthetic data. Sometimes we need real data, and we know that sometimes this is not something we can avoid. So our role in the project, in particular as legal advisor, was basically to make sure that this project, which is quite paradoxical, because we are talking about privacy preserving technology, so we are doing something for the good, but at the same time we need to process data, and this is also a challenge that we see in AI systems. Sometimes we need to process data to make sure that we implement better solutions, more accurate solutions, and this is definitely a challenge that we see very well connected with the current developments in the AI domain. And that's why also in this context of the project, from a legal perspective, we need to make sure that proper measures such as data protection impact assessment are carried out. Not yet the fundamental rights impact assessment, but this is definitely a scheme that we have to take into account every time we see the development of new technology and this kind of solution. So I think this project in a way is showing the potential in technology for facilitating compliance and at the same time for offering the advantages of the data-driven economy and the exploitation of big data on large scale. At the same time, I feel this is an interesting example of some of the aspects that we've seen together, and of the potential, as I said, of technology also as a form of regulation, as a possible tool for regulation. And in this respect, of course, with respect to AI and trying to connect my speech with what was said before, and in particular in the three previous speeches, I think that we need definitely to think about the potential of technology. And a point that I see as an endeavor that I think will trigger further academic conversation, but also, let's say, a more practical perspective, is the problem of making sure that we implement fundamental rights in a way that is consistent with the state of the art of technology, and sometimes using and relying technology. One of these examples, in my view, is machine learning. That is perhaps something that is still underestimated in its actual impact, but we know that we rely, of course, on the processing of the data on large scale. But what happens if data changes? What happens if content is no longer available? What happens if we need actually to change the mindset of algorithms and AI systems to make sure that, of course, when individuals, for example, wish their data to be removed, or I think about copyright right holders asking to remove certain content because they feel that they have an exclusive right. Then what happens with respect to AI systems, and particularly generative AI systems that were definitely trained before, at least the models were trained on the large data set, including also those pieces of information. This is a matter of alignment to make sure that we can have, of course, systems that are compatible and consistent with the state of the art of the information available on public sphere. You know that the AI Act tackles this point with Article 10 in the data quality requirements, setting certain specific requirements, but what if information is changing later, not only at the previous stage, but at the moment that there are some developments. And I think machine learning is definitely quite interesting examples of how technology can come into play also in this respect, in order, for example, to enforce or implement the right to erasure or other fundamental rights that we see protected in the Charter or in other constitutions. Of course, it's a technique that is still quite subject to debate. It's debated whether it's practical or not, whether we can make sure that inferences and correlation can no longer rely on data that were previously processed for training, whether it's possible to reopen, let's say, an AI model and to make sure that this is, let's say, retrained in a way consistent with the information available in the public sphere because of the exercise of certain fundamental rights. So I think that this is another interesting perspective that we perhaps will need to explore more in detail and deeply in the future, revealing the fact that, however, sometimes technology can also be supportive of the certain type of rights. We need to determine which technical conditions, in a way, meet the satisfaction of a fundamental right, the protection of that right. In a way, it calls back to my mind what happened in Google Spain, where we basically were just getting a message from the court adjusted that the removal from the search result generated by search engines meant right to cancellation, something that we already had in the GDPR, but actually was looking for a technical correspondent that we needed to understand which technical conditions were actually meeting that right in the specific technical content. And I think that perhaps what we can see also in the AI domain will be similar. And I think we will have a lot of conversations, so not only from an academic perspective, but combining also industry and policymakers on this, because I still see a disconnection. So thank you for your attention, and
Okay, so now it's time for questions. Happy to open it, you know. So, I mean, whoever wants to be an icebreaker, please, it's your time. Come on, let's open it. We have also 5 minutes more, maybe because, I mean, we have started 5 minutes later. Yes, please. If you want also to come here, it's fine, you know. Perfect. Okay. Mike, is there? Mike?
So again, I was working at the
Okay.
I was working at the medical sector, so there is still no regulation as long as I know about being used of how to use and access to the trainings data. I think the most important rules, for example, we build an AI tools. And the access to the data or trainings data, there is still no regulation who can access the data and how can the researcher use the data. So is there any binding implementing rules other than AI Act, so that at least we have some clear guidelines how to use and access the trainings data? Thank you.
Okay. Shall we collect some questions? So the first one is on training data. So is there any other question? Otherwise, I'm just, you know, ask the panel if they want to address this one. Yes, please.
Hi, I'm Peter. Hi, I'm Peter. My name is Peter Gaspar, and I have a question about the fundamental rights impact assessment. So obviously it makes sense to perform this assessment and investigate whether we are introducing any risks, but I think the focus should also be on introducing incremental risks. So AI can potentially create risks, but risks already exist. Decisions are made by humans. Humans can have good days and bad days. They come with biases, and these biases are very, very difficult to change, if possible at all. So shouldn't we look at basically on incremental risks? Yeah, maybe certain risks are created by the system, but maybe the systems can eliminate human biases and human problems, which are very, very difficult to fix.
Okay, shall we collect another one? Yes, please.
I was wondering, Simona talked about that the tools have to serve as a tool for the people, and that there is a high level of protection for safety and fundamental rights. What if you want to see if people are law-abiding, and I don't mean in the law enforcement area, but other areas of law enforcement. If you don't drive through a red light, for instance, things like that, just normal laws. What if the AI serves me as a person, because it has to serve as a tool for people, but it doesn't serve as a tool for you because you are being watched and monitored your behavior? How do you balance those rights?
Okay, so I would move to the panel at the moment, you know, just to answer these three questions. Access to training data, so it's to all of you, whoever actually wants to go first. There's one on fundamental rights impact assessment. Of course, it's open to all of you, but I will ask Michelle, of course, maybe to address that. And then we have the one on, of course, it was directed to Simone. It was for Simone, but of course, you are always free to start. So access to training data. Let me know who wants to go first. Or shall I do
I
that?
could say.
No, it's fine. No, please.
Yeah, I mean, I can say a few words about that. So, I mean, I think it really depends on sort of what the data is and who's holding it, right? But I think that's essentially shaped by the interplay of like the GDPR to the extent that this is personal data, but then of course you would also have the Data Act that kicks into place, like to the extent that maybe the data that you want to use as training data was generated.
Yeah, thanks.
Was
Nice.
generated in a scenario that falls within the scope of application of the Data Act. So I think it's really a contextual analysis, but we do have instruments in EU law that apply.
Marco, would you like to add something after this farm-style reminder?
I don't know if I got the question properly, but there might be also some provisions maybe in domestic jurisdictions sometimes concerning the processing of this kind of data for research purposes. It's generally something that is up to member states to regulate in more detail. So it may also depend on the choices taken by respective jurisdictions, which may also have an impact on the point of access, of course, which is a very
Yeah. Also because there are also leeways for member states to do something at the national level. Let's not forget that it's super important point when it comes to the enforcement. And on fundamental rights assessment, Michelle, if you can say something about this point on incremental risks and thinking about around that.
Yeah, so if I understood your question correctly, it was really about the sort of human bias and whether AI might be a tool to mitigate human bias. I mean, this is certainly something that people have been thinking about for a long time, right? That AI might also be, that you could also use it in areas where we know that human bias exists and might have detrimental effects. I mean, I think by and large, the concern is now that like oftentimes training, due to the fact that these systems rely on training data that itself might enshrine human biases, they then replicate these biases, right? So I think that's sort of the underlying assumption in relation to that. But I think if you account for that and if you can address that, then we can definitely think of use cases of AI systems that might help mitigate human biases, yeah. It all depends on how you use it, I think, and the governance mechanisms around it.
And to Simona, the honor to address the last question, please.
Yes, I mean, I would just say that the two are not exclusive. So having tools that are used for monitoring citizens' behavior, of course, is fine, and it's lawful as long as they don't encroach or infringe fundamental rights of those that are subject to the uses of AI. So the balancing would happen like that. It can be a tool to serve people in general, to serve a society, but it can also be a tool that affects the rights of the people that are subject to those uses. So this is where then we have to ensure that the protection can happen.
And I would say it's 10 o'clock, so maybe we can enjoy a break before the next of our session. Thank you so much for joining us, and let's thank again our panel. Thank you so much.